Hello and welcome to the ABA section of the Environment, Energy, and Resources podcast. My name is Matt Wickersham, Vice Chair for the Environmental Litigation and Toxic Tort Subcommittee. This podcast is part of our series concerning the major environmental cases that were decided in 2018. The section of Environment, Energy, and Resources publishes a year in review publication discussing the major environmental issues that have happened over the past year, and we have with us today one of the co-authors of the Environmental Litigation and Toxic Torts chapter to discuss his contribution to the year in review publication. Our guest today is Buddy Cox, a partner at Bradley LLP in Birmingham, Alabama, where he regularly advises clients on a variety of environmental matters, including property damage and personal injury lawsuits, administrative claims initiated by state and federal regulatory agencies, and remediation and natural resource damages claims. Buddy received his law degree from the University of Virginia School of Law. Buddy, thank you for joining us today.
Matt, thank you.
So what case was the subject of your contribution to the chapter?
Yes, I wrote about the Sixth Circuit decision in 2018 in the case styled Martin versus Bear Dayton Thermal Products.
And what issue was addressed in the Martin case?
In Martin, the Sixth Circuit reviewed and then affirmed a district court's certification of 7 issues for class treatment in a toxic tort class action arising out of groundwater contamination beneath numerous homes near a Superfund site in Dayton, Ohio. The Sixth Circuit adopted the so-called broad approach to issue certification that permits class treatment of certain issues even if the class as a whole or even a particular cause of action could not satisfy the predominance requirement of Rule 23b3 of the Federal Rules of Civil Procedure. After denying the plaintiff's proposed classes for failing to satisfy Rule 23b3, the district court rejected treating predominance as a threshold requirement that had to be satisfied with respect to the entire action, and then proceeded to certify certain issues for class treatment. Specifically, the district court identified 7 issues that would be tried, and the results of those issues, or however the cases are cases tried with respect to those issues, would be applicable to the entirety of the class.
So you mentioned issue and class certification. I was wondering, in a nutshell, could you discuss what the difference is between issue and class certification, especially in the context of environmental litigation?
Yes. Rule 23 of the Federal Rules of Civil Procedure lays out particular types of class actions, specifically identifies 3 types of class actions. And if a class is certified under one of those types of classes, then that decision in that case is generally binding on all class members, whether or not they're participants, whether or not they even know they're a putative class member. That decision can be binding on the entirety of the class. Issue certification is different. It's limited to particular issues that are articulated for class treatment, and it may or may not resolve the entire action. In fact, if in this case, it wouldn't resolve the entire action because the court specifically found that the proposed class wasn't suitable for class treatment as a whole, but the court went ahead and certified the particular issues for resolution as class issues. So that's the difference. And part of the problem in environmental cases, and one of the elements of what's called a B3 class or a Rule 23B3 class, is that the common questions of law or fact that are common to the class members have to predominate over any questions affecting only individual members. And oftentimes courts will find that the individual issues predominate over the class issues to such an extent that class treatment is not appropriate.
And so how has issue certification been addressed by the different circuits before the Martin case?
Well, the Sixth Circuit's opinion does a good job of explaining the different ways the circuit courts have resolved this. The Sixth Circuit identifies both what they call a broad and narrow view and then they also have a third approach that's been used by other circuits. So the broad view that was followed in the 2nd, 4th, 7th, and 9th Circuit, the predominance and superiority prongs under Rule 23b3 are considered after common issues have been identified for class treatment under 23c4. And then in contrast, the 5th Circuit has articulated the narrow view and basically doesn't allow an issue class if predominance has not been satisfied as a threshold matter. And then the third approach is recognized by the 3rd and 8th Circuit, and they take a functional superiority-like analysis. They don't take a hard either. They don't take the broad view that you consider predominance and superiority after you identify the issues for class certification, as opposed to the narrow view that says you have to have predominance and superiority before you can certify particular issues for class treatment.
Okay. You mentioned that the 6th Circuit adopted the broad view. How did they come down on that decision? What kind of issues did they analyze?
Well, under the broad view, the 6th Circuit said that the failure of the class as a whole to satisfy Rule 23b3 did not prevent the district court from certifying common issues for class treatment. The 6th Circuit believed that the narrow view rendered Rule 23c4, the provision that provides for issue certification, superfluous, and that the broad view maintained the rigor of Rule 23b3's predominance inquiry, and the court also viewed the broad approach consistent with Rule 23's text, as well as the reference to certification of issues when appropriate. And finally, the Martin Court indicated that the application of Rule 23b3's superiority requirement ensures that courts won't rely on issue certification where there exist only minor or insignificant questions, but instead ensures that the common issues would render issue certification the superior method of resolution. And then after adopting the broad view of issue certification, the 6th Circuit went a step further, and they also affirmed the 7 issues selected by the district court for class treatment, finding that the district court certified only issues capable of resolution with generalized class-wide proof, and that all 7 of the particular issues identified the district court needed only to be answered once because the answers could be applied in the same way to each property owner within the contaminated groundwater plumes. Now, the defendants did petition the United States Supreme Court for review, and in March of this year, the Supreme Court declined to review the case, despite the fact that you do have different approaches in different circuits.
So we're not going to have the Supreme Court coming in to give their opinion on this issue. Given that, what do you think the impact of the Martin case will be on future cases that consider whether or not to grant issue certification?
Well, I think it's going to be something that the proponents of the class, which is obviously usually the plaintiffs, will have to consider as an alternate form of or an alternative to a motion for class certification. And, particularly in environmental matters where, as I said, oftentimes courts will find that the individualized issues related to specific causation, individualized harm, individualized property damages and the like would predominate over potential class issues. So class certification as a whole isn't permitted. I do think that the proponent of the class will have to consider whether requests for issue certification or identification of common issues for class treatment is a strategy that they want to pursue, because it can be appealing to the district court as a case management tool. If you've got a situation where you have hundreds or thousands, even thousands of individual cases that are joined in a single action or a multitude of actions that are joined together, then the court is going to be looking for ways to try to expedite the resolution of those. And if class treatment isn't available, then issue certification can be a mechanism to avoid the series of trials or the repetition of the same evidence every single time. The particular issues that the district court certified and the Sixth Circuit agreed with, clearly reveal the trial judge's desire to avoid retrying the same issue for every single plaintiff. Issue one that was identified in both the district court and the Sixth Circuit opinion involved each defendant's role in creating the contamination within their respective groundwater contamination plumes, including their historical operations, disposal practices, and chemical uses. Now, it's not clear how the jury's determination of this issue will be applied or be brought forward into any particular plaintiff's claim, because a particular plaintiff will still have to prove their individualized harm, and so it's not clear how the district judge envisions applying those resolution of the issues to the individual cases, but that's something that has to be addressed at some point. The Sixth Circuit recognized several of these potential issues related to due process and fairness, but because the district court hadn't said specifically how it was going to proceed to apply the resolution of the certified issues in subsequent cases, the Sixth Circuit had nothing really to review.
Well, what are some of the other issues that attorneys should consider in deciding whether to pursue or how to oppose a request for issue certification?
One thing that, of course, is always a concern in class certification issues is the rights of the non-participant class members, the absent class members or putative class members. It's not clear under if all you have is issues certified like we had in the Martin case, whether the absent plaintiffs or absentee plaintiffs have a right to opt out, or do they have a right to receive notice that they're actually a member of the class or potential class, and that the resolution of particular issues, and a number of those issues that were identified by the court, go directly to the defendant's liability. And if you have a resolution of those issues in a way that is, in favor of the defendants in that case, you have an issue. You have a question presented of how do you let the absentee class members know that the decision has been, or the issue has been resolved against them. And that's a real struggle for both plaintiffs and defendants in class actions. The plaintiffs have to be concerned or plaintiffs' counsel have to be concerned from a ethical standpoint about what notice they're to provide. And of course, the defendants, if they're successful in a case, want to make sure it has the broadest preclusion effect that it can. None of those questions have really been answered in these cases, and so it's really kind of hard at this point to really assess whether issue certification is really going to advance the ball in managing the dockets where you do have mass cases filed by individuals and class treatment isn't appropriate.
Well, thank you again, buddy. This has been fascinating, and we really appreciate you providing your expertise and insights regarding this issue, which I'm sure we will see again being considered in the higher courts. Again, our program has been sponsored by the ABA section of Environment, Energy, and Resources. You can find out more about our section, including how to join, at our website, www.americanbar.org/environ. Till next time, this has been Matt Wickersham. Thanks for listening.